Enforcement challenges and victories. And I do want to say, if you feel like these panels are so amazing, which I think they are, that you want to watch them again, they are being recorded and they will be on our website. Or if, for example, you weren't here yesterday and you want to check out those panels, or you have any colleagues or friends who you think would benefit by seeing our panels, please let them know that they will be on our website. And also, we are going to create some publications out of these panels as well. So in case you don't have an hour and 15 minutes to watch a panel, but have the time to read, say, a 3-page or 4-page publication about it, that might be helpful. So we're going to create those as well. So keep an eye out for that. And so I want to introduce our moderator for the Enforcement Challenges and Victories panel. Anita Das is working with CAPI this summer as a research fellow. She's a practicing lawyer from Australia with an expertise in anti-corruption and anti-money laundering work, having worked both in the private sector and for an Australian judge. And she recently received her master's in law from Columbia. So Anita, lead us off.
Many thanks, Jennifer, for that introduction and also for the opportunity to participate and moderate this panel. Everyone, welcome to our very last panel for this conference. As indicated by the title, this panel will focus on some of the enforcement achievements and challenges faced by our speakers in their current and previous roles in relation to corruption, money laundering, and other integrity issues. Similar to the structure of our previous panels, our speakers will each make their presentation, and then there'll be an opportunity at the end for everyone to ask questions of any of our panelists. I don't want to take up too much of your time in the preamble, so I'll get on to introducing our speakers. Our first speaker is Mary Cagle, who is the Inspector General for the Miami-Dade County and the County School District. Her career includes many years of leadership and distinguished service at the Office of the State Attorney for the 11th Judicial Circuit. Her career is focused on the litigation and management of major investigations and prosecutions related to public corruption and organised crime. And while serving as the Chief Assistant to the State Attorney, she supervised special prosecutions, including litigation involving corruption, narcotics, gangs, economic crime, organised crime, racketeering and money laundering. Today, Mary will be discussing her current office's enforcement mission and particular cases of note that she's been working on. Our second speaker on the panel today is Wilson Leung. Wilson is currently the Global Ethics and Investigations Manager at HP. He has extensive prosecution experience. From 2008 to 2016, he served as an Assistant United States Attorney in the US Attorney's Office for the Northern District of California. Prior to that, he had served as an Assistant United States Attorney in the Southern District of New York from 2001 to 2008. Today, I believe that Wilson will be talking about a particular case study, United States versus Leland. Our final speaker on the panel today will be Nick Maxwell. In 2016, he founded the consulting and research company NJM Advisory. NJM Advisory focuses on anti-corruption and anti-money laundering research and events that bring together private, public and third-party stakeholders to improve the combating of corruption, money laundering, terrorist financing and human trafficking issues. Prior to the launch of his firm, Nick headed up the Transparency International team focused on the May 2016 London Anti-Corruption Summit. Today, Nick will be presenting on the enforcement challenges facing the stemming of the flow of corrupt money into high-end or luxury real estate. So I'd now like to turn over to our first speaker, Mary. Thanks.
Good morning. It's a pleasure to be here, and thank you, Jennifer. I appreciate the invitation very much and have had a really good time. It's nice to speak on the second day because the people in the audience have sort of become your friends. The first day, you don't know anybody, so it's really nice to be here. Okay, so I'm going to share some thoughts on sort of our mutual goals of enhancing public integrity. And I think OIGs, Inspectors General, have sort of a unique role in this process. Like as a state prosecutor, I don't remember really focusing on sort of the Inspector General in our community, and now I find myself the Inspector General in our community. And I think it's sort of a unique role, and the Miami office, like a lot of other people have talked about, really kind of grew out of, in the 90s, a whole series of corruption cases where high-level administrators in the city and the county and some commissioners were indicted, prosecuted, and the public basically rose up and discussed, and they passed the ordinance that created the Inspector General's office. So I wanted to start with sort of this list of 5 things. They're just, some of them are really simple, right? But let's see if I can get them up there. Okay, so we've talked a lot about independence, and I'm going to talk a little bit more about it in a minute, but that to me is like a core piece of what you need if you're in an IG's office and you're going to do enforcement work. I mean, the public has to perceive you as somebody who is independent from the administration. Secondly, hiring the right staff. One of the things I have found in the almost 4 years that I've been the Miami's IG is that, you know, we're inspectors general, so we're generalists. If you don't hire the right staff, you can't do effective enforcement. So, for example, at Water and Sewer, we hired an engineer to go out there, somebody who had contracted over the years and knew contracting, because for me to put a lawyer or a CPA out at the Water and Sewer Department wasn't going to do me a whole lot of good. I needed to put somebody out there who understood where fraud can occur in a contract. So, but our, you know, our analysts, our investigators, these people have to be smart enough so that when they go into the department, they can learn the department as well as the people who actually work in that department. So when we come out with our report and we issue recommendations, they actually are recommendations that people value because we know what we're talking about. So the third thing for our office that I would say has really made us effective in enforcement, and this is really because the criminal cases we make are often the things that really hit the high profile and help the public be aware of the fact that we exist. But 2 of our lawyers in the office are ex-prosecutors and are actually sworn in by the state attorney's office to prosecute our cases. So once we open that as a criminal investigation, those people report directly to the public corruption state attorney in that office, the guy who runs that division. But it's been incredibly effective, and I'll talk a little bit more of that in a second. Also, our whistleblower work. We, a year ago, amended our whistleblower local ordinance, and into that legislation, we put an outreach piece. So that's given us a mandate to go out through the county and really, you know, hit every single county employee to make them aware of what we do. And finally, I would say understand the 5th thing I think that is needed for effective enforcement is really understanding the balance between having a good relationship with the administration, because you want these people to implement the recommendations you make because you're trying to improve government, right? But boy, if you cross the line to what I would almost say is even friendship, you really run the risk of when something happens in their department not wanting to really follow your facts and call a fact and hit them where the facts take you. So that, I don't think I fully appreciated that when I came on as IG, but I think that's a very, very important piece to understand that balance. Okay, so everybody's talking about contacts and Bogota and, you know, Paris and, okay, well, I'm only Miami, but let me tell you a little bit about Miami. Okay, that's a picture out of my new office window, and the big tall building is County Hall. And you see the building with the triangle top. So for example, that's our county courthouse. It's in complete and total disarray. Falling apart. I bumped into the chief judge the other day buying coffee on a Saturday, and she started telling me again how terrible it is and how literally one of the judges had, he didn't know it at the time. He thought it was water, but they found out it was urine dropping on his head from a floor above. So one of the things we did was we went in and we were asked to investigate whether or not, because all these buildings, when they hit 40 years, have to have a 40-year inspection, right? And then subsequent 10-year inspection. So what in the world happened that the courthouse is like this? So we monitor that, we write a report. You see well, another thing that they're looking at for the courthouse is building a new one using the model of they call them P3s now, right? These public-private partnerships. So, and why are they looking at using a P3 to build a new civil courthouse? Because they went out to the voters already and asked them to pass bonds to build a courthouse, and the voters said, don't think so. So they have to come up with a new procurement model. So the rail coming through the middle of that picture, you see that? That's our Metro rail going into downtown. Here you see that's right on the side of the Metro rail. So they're building everywhere in Miami, doing all kinds of capital improvement projects. We monitor them. Here you see this is going to be all aboard a train to Orlando with condos, restaurants, office buildings. Next to it will be the World Center, and they tell me that the World Center, when built, will have enough seating for 17,000 diners at a time, almost as much as the rest of the city. I only put this up here so that you can see, again, that's the picture out our window, and they're about to block my view of the water, so I don't appreciate that. Okay, so the capital improvement projects and the dollars, so you've got right now, $13.5 billion over 13 years to improve our water and sewer infrastructure. So we're under a consent decree. We've got all the deadlines and fines, and we have ocean outfall legislation, so we can't dump our treated waste into the water anymore, so we've got to reverse the flow of all of that. So again, we have an engineer who's on site out at water and sewer for all of that. We're touching every hospital connected to our major public health system in Miami, and we passed bonds in the amount of $830 million for that. And we have a $1.2 billion bond to rehab all the schools in Miami. As we said a minute ago in the introduction, through an interlocal agreement, we're also the IG for the school district. So on these capital improvement projects, again, we have auditors or contract oversight specialists monitoring all of that. So this is our new office. So you see the tall building there, we're on the top floor. We tried to create little Google space, you can see that. But it's amazing because the way they built it out, the county architect worked with us so that our auditors and our investigators are side by side, and it's just given a holistic approach to the work. Everybody's talking about everything. When somebody needs this expertise, the person is right there. We used to be in a chopped up office and not conducive to the work. Okay, we have a $7 million budget and 38 employees. And so that's kind of how we break out. So all three of these divisions do enforcement work. Our investigations unit, and let me talk a little bit about this designation for the lawyers, but investigations works criminal cases with the state attorney's public corruption task force. So when we initiate something, we might work it for a while, but at some point, if we open it as a criminal investigation at the state attorney's office, then our lawyer, who is sworn in as a special assistant state attorney, can carry that through all the way through trial. My counterparts, other local IGs, if you talk to them, especially in Florida, they will tell you one of their biggest frustrations in terms of enforcement is not being able to get the local state attorney to file their cases. And you know, that can be a real struggle. So this has been a huge advantage for us. We don't have arrest powers, but we do have a specific piece in our ordinance that clearly authorizes us to work with law enforcement through to the conclusion of any criminal case. So these guys also, the investigators, do administrative inspections and reviews of departments, and then when they do that, they do recommendations with 90-day follow-ups until we get where we want to be with them. Our audit staff, they can initiate audits either through a complaint or self-initiate because we've identified an issue where we think if we do an audit, we can add value to that department. So, for example, at our airport, the permittees, we call them, who actually service the airlines, right? So your people who are your baggage handlers, or maybe you clean the airplane before it takes off. All these people have to get a permit from the airport itself. Okay, so I'm not sure whose idea this was, but they self-report their gross revenue and then have to pay a 7% opportunity fee to the airport, right? So if any permittee pays a 7% opportunity fee. So if you self-report, the motivation to report accurately is like, there is zero motivation there to report accurately. Let me just put it that way. So we began a series of audits to really kind of look at what was actually going on, and found out that they don't even disclose, you know, who all they service. So like we had a permittee recently when we were doing this audit, and you know, they claimed and reported that they serviced American Airlines, right? Well, somebody saw them over at Delta and came back and said, do they service Delta? And no, they hadn't reported that. And so that was, we went back, and that was $1 million of business, that 7% of that they owed the airport. So we're trying to do a series of audits and make recommendations so that there will be some controls in place that will ensure more accurate reporting. Now, our contract oversight function sits in our legal unit, and I think these guys are scary smart. These are people that we went out and found who know the county budget inside and out, who actually read the county budget. They're our engineers. They're people who really understand the work, and they've been absolutely invaluable. So, for example, we're converting our fleet of buses in Miami from diesel fuel to compressed natural gas. The contract was awarded to a company named Trillium on like a turnkey basis, right? So they were supposed to purchase the buses, upgrade the maintenance facilities, and do everything from the beginning to the end, turnkey, to make this happen, right? So they've just started, and they come back to the county and they basically say, we didn't realize it, but we need another gas line. Okay. So the county moves forward with just figuring that, okay, you need another gas line, we'll pay for that. And, you know, so our guy who's doing contract oversight over that particular contract then pushes back with the county and says, no, go back and look at your own contract. This is a turnkey solution. You shouldn't be having the financial responsibility to do this. They should. So then they push back with the company, and the next thing you know, that's not a financial hit to the county, but it takes somebody watching the public's money to push back and make sure, you know, they abide by the terms of the contract. Another example of the contract oversight work, we recently asked the committee chair of the commission to defer a bid waiver they were going to vote on for a month, because we had a complaint about why was this going to be a bid waiver for $12 million. And so they were going to install traffic controllers, so they synchronize the lights, and they can, don't ask me how this works, but they can feel who's in the turn lane, so you don't put the arrow on if you don't need the arrow, and all of that, you know, all this brilliant technology. So they're coming with a bid waiver for a company called Econolite. And so we had some allegations, and so we asked them to defer it, and we looked at, is the bid waiver necessary? If you allow them to do a bid waiver here, this is just for 10 corridors. They've done a pilot project, now they're gonna do 10 busiest corridors in Miami with a bid waiver, and then we're gonna do the entire county. So are they setting this up so that there will be zero competition? Because if there's gonna be zero competition in the go forward, then you're not gonna get the best price for the work. So, you know, it's just this whole series of I call that our prevention work to try and, stop it before it happens. So our independence, again, I said I thought our independence was critical to our work and to our enforcement. So your independence, I think, goes to having credibility with your stakeholders and with the public. And it also hits your whistleblower work. I'll talk about that in a second. But so it's easy to say, we're independent. What does that mean? Okay, so the IG is actually selected by an independent ad hoc panel. So a group of like your state attorney, your public defender, and 3 other people come together when there's a vacancy, and they do a search and they select the IG, and one name goes to the county commission and they vote that name in or out. But I was the first person to go through the process, and I mean, it was a very apolitical process with no lobbying, no nothing, basically a selection process. Our funding is a 1/4% of all contracts that are let, so you have a constant funding stream that nobody can turn the faucet off if you go after somebody that makes somebody unhappy. I am on a 4-year contract. Now, the one thing I'll say about our independence that we're still working on, because I think overall it's a pretty good independence model, but we're not in the charter. And this year they're doing charter review, and we hope to put that issue before the voters, because if we're in the charter, it takes the voters, to abolish the IG. Right now, 2/3 of the county commission could in fact abolish the Inspector General's office. Okay, so they call us watchdogs, right? And so I put this up here to give you a sense of the county. It's a fascinating place, $7 billion annual budget, 28,000 employees. So we're 38 people at an IG's office. And so I teach the new employees every Tuesday, a class of 25 reoccurring, so you can see they have a lot of turnover in the county. And so, I think it's a legitimate question to ask, what can 38 people do in a county this size, right? So to address that, we entered into work with our county commission and our administration to amend our local whistleblower law. It's actually called the Employee Protection Ordinance. And so there were people in the county who didn't know the OIG existed, and it's been there since 1998. And they certainly didn't know where to go to lodge complaints. And I mean, some did, but some didn't, right? So they didn't know what their protections were. They didn't know that we could keep their identity confidential if they came forward. So we decided, let you look at this slide a second. This is a slide I actually use in the new employee training, but we decided we could be far more effective if we went out and used that 28,000 workforce and the people in it who want to do good public service. If they connected to us and understood their protections and how to report fraud, we could have a much bigger impact. So into the legislation, they put that the IG has to do outreach to all 28,000 county employees, which was great because it gave me a platform to really go out and start meeting with everybody. So that's the video that's being put out. And so it lays out all the specifics of the whistleblower law, what the role of the OIG is in county government, where and how employees can report to us, specifically trains them on their protections, specifically this piece about after the case is closed, because everything's confidential during an active investigation, but after the case is closed, their identity remains confidential. So we've taken this video and done outreach, not just through the video, but also through live trainings all throughout the county, airport, seaport, parks, transit, all these county departments. And we talk to them about what our work is about. We give them examples. But most importantly, we talk to them about confidentiality. And we talk to them about, they want to know, how does that work? If I come in and you tell me you're going to keep my identity confidential, what happens when somebody gets arrested and the Miami Herald calls you and they want a copy of the file? And so we tell them, this law gives us the authority to redact anything in the file that would lead to the identity of the whistleblower. And that seems to be incredibly important to them. On Tuesdays, when I talk to these 25 new employees every Tuesday, and I always have this dialogue with them, like if you saw somebody stealing in your department, what would you want to do? Oh, I would want to come forward and tell somebody what I saw. But honestly, I'm not sure I would, because I would be afraid, especially if it was my boss, right? I always ask them, what would be the most important thing to you? They always tell me the same thing. I've had this has been almost a universal response. I would want to know that my identity could be kept confidential. So we wrote that into the law consistent with our state law, and I think it makes a huge difference. Okay, one last thing. Can I do one last thing? Okay. So this is just, I'm going to just close with this. This is an example of why this law is so important. And so this guy was the security chief in the county. So what does that mean? He would buy alarm equipment using county money, and he would install it with his team of 4 in county buildings. So what did he do? Okay, he actually ran a security company on the side that he didn't disclose to anybody. And so he was buying the alarm equipment with the county money, and yes, he was installing some of it in county buildings, because you have to commit the fraud, right? But he was also, fraudulently changing invoices so that he could also cover up his crime and install that same equipment purchased on the county dime in all of his customers' residences and businesses. How did we find out about this? This went on for 20 years. I mean, really unbelievable. This guy was the supervisor for 20 years. And what happened was a county employee, didn't work in that department, but close enough to hear all the rumors, was disciplined for something that he thought was ridiculous. And actually, when he came in, we thought it was ridiculous, right? He told us what had happened. He said, I know this doesn't have anything to do with what I'm going to tell you, but if they're going to discipline me for this, let me tell you what this guy's doing. And so he dumped his guts. We put our auditors on looking at all these invoices, and we put our investigators on going out, doing the surveillance, doing search warrants, whatever, and we made a case against this guy. We only picked a 1-year period of time, right? Because that's what our resources limited to us. He stole $200,000 in that 1 year, and this is what he went to jail for 6 months, and then he was followed by house arrest and then probation, lost his county pension, and he had to pay restitution. So those of you who do criminal law, you pay restitution for what the government can prove that you stole. So he walked into criminal court on the day he took his plea, pulled out his checkbook, and cut the county a check for $200,000. Which always gives me pause. Imagine the amount of money this guy stole, right? And to this day, nobody knows who the whistleblower is who brought us that case. So I will close with that. Thank you so much.
Many thanks, Mary. That was really interesting. I'll now hand it over to our second speaker, Wilson.
Thank you very much, Nita, and thank you, Jennifer and CAPI, for inviting me to speak here today. Let me see if I could, let me see if I could figure out how to, oh man. I just failed the first test, which is figuring out how to work the PowerPoint system. Did it come back? Middle one. Perfect, right. There we go. Thank you very much. So I wanted to take some time to show you guys how PowerPoint works and how to get it back up on the screen. So that was a demonstration. Again, thank you very much. I'm here to talk about an enforcement victory in the Northern District of California, which is centered in San Francisco. And this is a case, a federal prosecution called United States versus Leung. Leung was a prominent local San Francisco politician, and he was a state senator at the time he was arrested and charged in 2014. On July 1st, 2015, he pleaded guilty to 1 count of racketeering conspiracy, which is a very serious crime under federal law. And so I wanted to go over the tragedy and sometimes farce of what happened with him. Before I begin, however, I'd like to issue some standard disclaimers. I used to be an AUSA, an assistant U.S. attorney in San Francisco, and during my time there, I was the deputy chief of the organized crime unit. While I didn't personally work on this case directly, it happened while I was in the office. Any comments I make here today is not a reflection of what the DOJ's position would be. In fact, some defendants in this case are still pending. In addition, I'm only commenting in my private capacity as an individual, not on behalf of HP. And also, I'm only going to comment on publicly available information. All right? So just think of this as a friendly conversation between an enthusiast, a hobbyist, about current events. So Leland Yee was a prominent local politician in San Francisco. I grew up in San Francisco, and Leland Yee's brand was always in the background. And we're talking about the days before social media, before mass advertising. He began his career, as many San Francisco politicians do, with a run for the local school board. He served as president of the school board in his second and last term. Then he got a promotion up to the local board of supervisors, which is the panel of local legislators who manage the city's affairs. After 2 terms as a supervisor representing his home district in the Sunset, I don't know if you guys know San Francisco, that's just south of Golden Gate Park. He then got another promotion to the State Assembly, which is the lower house. As an assemblyman, he was known for 2 principal causes, which is passing a law that made it a misdemeanor for vendors to sell mature-themed video games to minors. And as you'll see, ironically, he was also known as a gun control advocate, commenting that no Californian should have any sort of assault-type weapons, which is a fairly non-controversial position in California. But it'll be ironic as we discuss what happened in this case. Following 2 terms in the Assembly, he then moved on to the upper house of the California legislature. He became a state senator representing part of San Francisco and San Mateo County. And it was during his second term as a state senator in 2014 when he contemplated a run for Secretary of State that he needed to raise money. And in fact, by way of background, in 2011, while he was state senator, he ran unsuccessfully for mayor of San Francisco. And he came in 5th out of a large pool. And as a result of that failed campaign, his campaign owed about $70,000 in debts to various vendors. And before he could contemplate a run for statewide office, Secretary of State, he needed to retire that debt, as well as raise new money for the Secretary of State campaign. So we're now talking 2011, and Leland Yee needed money. And so what happened then is this man came into the picture. This man is named Kwok Chung Chow, also known as Raymond Chow, but known more popularly and in the vernacular as Shrimp Boy. And Shrimp Boy came to the U.S. from Hong Kong when he was 16. He became a gangbanger on the streets of San Francisco and in the communities of Chinatown. He has a long history of convictions. Did 7 years in state prison for robbery, armed robbery. He did another 3 years at some point in the 80s for attempted murder and assault with a dangerous weapon. Then in 1995, he teamed up with a Hong Kong triad member named Peter Chong to form something called the Whole Earth Society, which is essentially an organization that sought to control all Asian organized crime in San Francisco. In 1995, he was convicted federally for firearms and prostitution-related offenses and was sentenced to almost 24 years in prison. Unfortunately, that's not the end of Shrimp Boy, because Peter Chong had fled to Hong Kong and was subsequently extradited back to the U.S. to face prosecution. And the federal government at the time decided to make Shrimp Boy its cooperator. So as a result, Shrimp Boy never served his 23-plus years in prison. Rather, he served until 2003 by cooperating against Peter Chong and was released. There was some misgivings, however, about whether Shrimp Boy should have been signed up, because afterwards he sought entry into the Witness Protection Program and was denied, and there were efforts to deport him. However, Shrimp Boy fought the deportation at the time of his arrest. He was arrested in 2014 with Leland Yee as well. At the time of his arrest in 2014, he was still fighting his arrest and was on an ankle monitor, being monitored by immigration authorities. So, Shrimp Boy is a well-known figure in San Francisco's Chinese underworld. And he was particularly notorious because after his release in 2003, he professed to be reformed. He spoke at schools, told kids to stay away from alcohol and drugs and to study hard, do their math, etc. But there was always this vibe about him that he hadn't fully disengaged from the underworld. He would grant interviews and talk about his past. He was working on a book and a movie deal. His book was called Son of the Underworld. I don't think it was ever published. And then in 2006, an odd coincidence happened. The Qigong Tong is also known as the Chinese Freemasons in San Francisco. It's a civic society, a fraternal society. It provides cultural it sponsors cultural events in San Francisco. It also provides social services for recent immigrants. And some say periodically it's also an organized crime front. And in 2006, the leader of the Qigong Tong, the Dragon Head, was named Alan Leung, no relation to me. And in 2006, a masked gunman entered his import-export shop in Chinatown, and it's always an import-export shop in which these crimes happen, and shot him dead, didn't take anything, didn't harm his wife who was there. And people wondered what happened. And of course, suspicion immediately fell upon Shrimp Boy, because in 2006, after Alan Leung's murder, Shrimp Boy was named the new Dragon Head of the Qigong Tong. And so the coincidence was rather bizarre. Now, what does an organized crime figure like Shrimp Boy have to do with Leland Yee? Well, enter this gentleman. His name is Keith Jackson. He is a product of San Francisco, a product of its schools, and at the age of 30, he was elected to the school board like Leland Yee was. And in fact, he also served in his second term as president of the school board and was the youngest president of the school board in the history of San Francisco politics. Following his tenure on the school board, he had several city jobs, but then decided to open up his own consulting firm called Jackson Consultancy. And as one of his clients, he had Leland Yee. And he was also named as a consultant for the Qigong Tong as well. And I don't know if this was an official position or contractual position, but he and Shrimp Boy had met because he sought Shrimp Boy's support for a real estate development in the Bayview Hunters Point area, which is a neighborhood in southeast San Francisco. So as a result, in 2010, the federal government launched an investigation of Shrimp Boy, and this involved an extensive multi-year investigation involving an undercover agent who pretended to be an associate of La Cosa Nostra, the Italian-American mafia in New Jersey. And he met up with Shrimp Boy and a lot of his associates and recorded Shrimp Boy and his associates talking about the commission of various crimes. And during the course of this investigation, spanning from May 2010 all the way through roughly July of 2014, the undercover Shrimp Boy and or his associates laundered more than $2 million worth of putative drug and drug proceeds or proceeds from illegal bookmaking. They made more than $30,000 in the sale of putative stolen alcohol. They also made more than $400,000 in the sale of putative stolen cigarettes. And of course, after each transaction, the undercover gave Shrimp Boy a portion of the proceeds. Shrimp Boy would say, no, 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 don't give it to me, but then he'd take the envelope. So that was the undercover organized crime investigation. It was called Operation White Suit because Shrimp Boy notoriously showed up at Alan Leung's funeral wearing a white suit when everyone else wore black. But during the course of Operation White Suit, a strange thing happened, which is that Shrimp Boy introduced the undercover to Keith Jackson. And this happened in August of 2010. And Keith Jackson immediately started soliciting the undercover, whom he believed to be a La Cosa Nostra affiliate, for donations to Leland Yee's campaign. And he kept asking the undercover for money, in excess of, at the time, the $500 campaign limit for the mayoral campaign. And at this time, by this time, Leung Yi had already lost the mayoral election but owed $70,000. And he was desperate to retire that debt. So as a result, during the next 2 years, Keith Jackson kept imploring the undercover to engage in crimes, both on his own behalf and his son's behalf. For instance, Keith Jackson asked for drugs, offered to sell guns, and also his son offered to kill someone for this undercover. But he would also seek illegal money to help Leung Yi's campaign. And this culminated over the years with about 4 payments totaling $37,800 that the original undercover and a subsequent undercover made to Leung Yi at various points, in exchange for things such as a phone call to a state official to help another undercover who pretended to be a contractor for the state. The undercover paid $6,800 in exchange for an official state proclamation issued to the Qikongtang, proclaiming it to be a laudable civic organization. And through the original undercover, additional undercovers were introduced to Leung Yi, who made contributions of $10,000, $11,000. So Leung Yi would promise to support legislation that they favored, such as legislation that would require a doctor at every medical marijuana dispensary, or legislation requiring heightened labor requirements for a sports team, because that ostensibly was what these lobbyists wanted. And the odd thing is, as set forth in a public criminal complaint, Leung Yi had misgivings about doing this. He complained to Keith Jackson that what was being asked of him was pay to play, completely illegal, was worried about getting caught. And yet, he proceeded to do so. Because I think more telling was the fact that during these intercepted calls, he also consistently berated Keith Jackson for failing to raise enough money for him, because he needed to get rid of the $70,000 debt so he can move on to higher office. And as a result, you have his arrest and indictment and his eventual plea. And the fascinating thing is he eventually pled to racketeering conspiracy, which means that he operated his campaign, both his mayoral campaign and his failed Secretary of State campaign, as a racketeering enterprise. And the underlying crimes for the racketeering enterprise consisted of honest services wire fraud. That means he deceived, or he defrauded the people of the state of California by taking bribes. Obtaining property under color of authority, which means that he demanded money in exchange for consideration of certain legislation. Money laundering, because he directed Keith Jackson to take some of the cash that was given to him and cut it up into smaller checks. But the odd thing is, he also was engaged in weapons importation, which is not a crime that you usually see in a public corruption case. And what happened was, beginning in about August of 2013, Keith Jackson told the undercover that Leung Yi knew someone in the Philippines who had access to weapons. And the undercover said, sure, I want to buy a ton of guns and missiles and shoulder-launched rockets and import them through New Jersey because I am a member of the mafia. And so they held 4 meetings at which Leung Yi attended. And I kid you not, Leung Yi actually engaged in discussions over the next several months concerning how to import these weapons from the moral Islamic fundamental group into the U.S. via New Jersey. Another reason not to go to Jersey. And this wasn't even the undercover's idea. This was Leung Yi's idea. And he engaged in extensive conversations about the import of weapons. And that's the irony, because he was known in the state assembly as a champion of gun control. So Leung Yi is now doing 5 years in an FCI facility in Fort Worth. Keith Jackson also pled guilty. I forgot exactly how much time he got. He's probably doing more because of the murder for hire scheme that he also pled guilty to. Shrimp Boy is doing life because he was eventually convicted of Alan Leung's murder as well as the murder of someone else. So this has the elements of a Greek tragedy, except for the fact that a lot of their conduct was very banal and stupid, which leads me to some musings. And I don't want to call them conclusions because that implies some sort of rational scientific basis. These are musings, and I wonder what possessed Leland Yee to do what he did. The obvious is that he needed money, right? And money pervades politics. And and he was willing to compromise himself and his campaign for a paltry $70,000 debt and money for the Secretary of State position. And it seemed like no amount was too small for him to try to get. And that's very, very unfortunate because he was the second highest Asian American politician in the history of California at one point, and he came crashing down due to his own greed. And the odd thing is, there seemed to be a duality about Leland Yee because even though his outward demeanor was kind and he always talked about how careful and cautious he was, in fact, he bragged about how his caution kept his political career afloat, he engaged in some crazy misconduct, notably the gun charges. And he always told the UC, the undercover, to be careful. Yet he himself did not practice what he preached. And so if we were to engage in a psychological profile, I wonder if he was suffering from some crazy midlife crisis or just a complete sociopath who just could not comprehend the consequences of what he did. But also, San Francisco is a small town, 800,000 people, and it's ruled by the Democratic Party, always been so. And I also wonder if single-party rule necessarily breeds more corruption or more opportunities for corruption because of the fact that you then count on individuals, people like Shrimp Boy, who wield power in the community, as opposed to institutions to gain political standing. And so I will leave you on that thought and contemplate the tragedy, the farce, but the very titillating case of Leland Yee and his foray into the underworld. Thank you.
Thank you, Wilson. I think that could be made into a very popular movie. I'll now introduce our final speaker, Nick Maxwell.
I'm glad I didn't have to do that. So delighted to be here, and thank you again for the invitation. Slightly shifting gear, I'll be talking about the proceeds of international corruption and how they can be flowing into our global cities, what the vulnerabilities are and what the enforcement challenges are. As per the bio, my research agency, we focus on public-private collaboration in the fight against corruption and serious money laundering. Prior to that, I led the Transparency International research program on this particular issue, and I was very proud in the last panel that all three cities, Colombia and South Africa and in Paris, were relying on Transparency International research. So I was asked to speak about the TI research in this presentation. So we heard about London and Paris and Bogota, but if you're coming to London as a tourist, if you'd like to learn more about the city, you can go on what's called the Kleptocrats Tour. It's a bus ride. You go around all around the city, the nicest parts of the city, and you can find out the history of some of the homes and allegations around current owners, offshore structures holding the property, and links to grand corruption overseas. The picture of the main building you see is the largest building outside a royal home in London, associated to a senator from Russia within Putin's inner circle, who's also a fertilizer oligarch. You'll also see buildings related to the Kazakh secret police chief, who's connected to several murders. You'll also be brought to Gaddafi's sons' homes and property related to Mubarak and his circle in Egypt. So it's quite a tour. And it just goes to show some of the vulnerabilities that I'll be talking about right now. And while I'll be focused on research that relates to London and the vulnerabilities of corrupt capital flowing into the city, it's a problem right around the world. So our global cities, as this conference is focused on, are all vulnerable to this issue because the state of enforcement is so poor. So whether it's New York or Vancouver, Sydney, Melbourne, Paris, Miami, these are issues. Why? There's widespread flows of illicit flows, the proceeds of corruption. We're talking about the proceeds of corruption today, but it also applies to the proceeds of serious and organized crime, narcotics, human trafficking. And there's vulnerabilities. So in most jurisdictions around the world, it's very, very easy to launder money into real estate. You can use secret companies, offshore companies, where the ultimate beneficial owner never has to be declared and certainly not available to the public or to law enforcement in that country. And therefore, there are big challenges in enforcing these crimes and in law enforcement prosecutions. But really, the vulnerability stems from the fact of why these properties are so popular. It's the same reason that they're popular for legitimate investment. They're a very useful store of value, often increasing at an exponential rate in some of these global cities. And it's a store of wealth. But particularly for the proceeds of international corruption, they're taking money stolen from some of the most vulnerable countries in the world, and they're taking it out of that legal system, out of where they might be vulnerable from, changing government and keeping that wealth secure. Okay, so there are estimates of the scale of illicit flows around the world. I'll just summarize that by saying that they're huge. So Global Financial Integrity estimates 1.1 trillion per year stolen from developing countries and flowing around our major financial centers. In the UK, where the law enforcement attention on international proceeds of corruption is quite high, certainly one of the strongest in the world, they still estimate that up to hundreds of billions of pounds are laundered through the UK every year. Case studies further demonstrate the point about it being an international problem. You don't have to go very far. And whether it's, in most cases of grand corruption, there is going to be a link to luxury property. And the problem is that so few cases of grand corruption ever reach a judicial or law enforcement prosecution end state. So, one of the big vulnerabilities is, as I said at the start, is corporate secrecy, and we'll be talking about that in terms of our study of vulnerability of global cities to these illicit flows. So in our research, we worked with the Metropolitan Police, who had a dedicated proceeds of corruption unit, and to bring out the meta-level data on their investigations. And they identified 180 million pounds worth of property that were criminally under investigation as the proceeds of international corruption. Sounds like a high number to some people, 180 million, but it's not a high number when it comes to the overall flows suspected to come through London every single year. Key thing was the domination of offshore companies holding the property. So incredibly difficult for law enforcement to unpeel who actually owns this property. They might have the first company, but it might be owned by a company in a British overseas territory, like the British Virgin Islands. It could be owned by a Crown dependency, a company registered in the Crown dependency, like the Isle of Man or Jersey. Then perhaps by a company in Delaware, then by a company in Panama, then by a trust, all concealing the beneficial owner. In the World Bank study of all of the cases of grand corruption that had been brought to trial at that point, they summarized that the use of offshore companies to support the laundering of the proceeds of corruption was almost ubiquitous in their cases that they had investigated. So what we looked at in terms of our research, well, let's just try and find out how much of London is owned by offshore companies. It hadn't been done before. What we did was had a research collaboration with our land registry, where we were able to take the kind of big data analytics to play on corporate holdings. So we had access to all corporate holdings of property title, not personal holdings. And we combined that with other registry information and, as I mentioned, in collaboration with law enforcement to understand particular risk factors. So what we found, our first research volley on this was in 2014. Over 40,000 properties around London held by foreign companies. So that's any company. But over 90% of those were held by companies incorporated in secrecy jurisdictions. We used the IMF list of tax havens to define that list. But what was so interesting for the UK is, they didn't have to go very far. They used British overseas territories, by far and away dominant in terms of the companies incorporated in British overseas territories holding property in London. The biggest player in that was companies incorporated in the British Virgin Islands. Over a third of all the property company holdings of property were incorporated in the British Virgin Islands. We repeated the research in 2016, and the problem got worse. So more land titles held by companies, and the percentage of which held by companies incorporated in secrecy jurisdiction had risen. So what can we find out from a bit of the geography? So it's highly concentrated in a few of the London boroughs, and in particular the city of Westminster, which is as central London as you can get. Almost 1 in 10 properties there were held by a company from an offshore secrecy jurisdiction. Also Kensington and Chelsea, but it's highly concentrated in the boroughs where there is a high concentration of luxury real estate at the highest end of the market. So that just is an infographic to kind of demonstrate that concentration relative to the other boroughs in London. This really is a luxury end of the market. And overall, it's 120 billion pounds worth of property that were held by offshore companies. In terms of land mileage, that's about 2.25 square miles of London. So other indicators of risk. We know that offshore companies are an indicator of risk of money laundering. But part of the problem with the luxury end of property real estate in London is the domination of buyers from high-risk countries when it comes to corruption risk. So as we move to the right of this chart, we're talking about the most valuable property in London, so £2,000 per square foot, something like $2,200. And you'll see the growing role of Russia and former Soviet republics into that as buyers into that higher end. Also, big components from the Middle East and from China. This data is drawn from real estate surveys. So this is a real estate trade body surveying its own members. So it's not law enforcement data. It's not publicly available data. It's the real estate sector describing, where the customers are for the particular parts of the market. Limited law enforcement response overall. There are a few cases that have been brought to trial and asset recovery. Perhaps most famous is James Abori, a former state governor from Nigeria, who had a range of properties, and the largest in Hampstead. Sadi Gaddafi, one of Gaddafi's sons, property in Hampstead was recovered through a private civil action, over £10 million property. But really, there's not much enforcement. We've got a few kind of isolated case studies where we've had some limited success. James Abori is actually doing a continuing legal fight in defense of that asset recovery. Overall, the AML regime is meant to prevent this kind of activity. We're meant to spot money laundering at the front end. It's meant to be reported so that transactions can be identified that are suspicious. And that system, largely doesn't work with regard to this crime. The level of deterrent is very low. So the average fine in the UK is £1,000. And if you think just about £1 million property, which is relatively cheap when it comes to London, the commission that they might expect is around £20,000. So it's not a dissuasive fine. Similar case in Canada. More broadly, these checks, these anti-money laundering checks, don't actually exist in many countries. So in Australia and the US, for the real estate sector, there aren't the same level of obligations for real estate professionals to spot and identify suspicion and report that. In the EU, where there is an obligation on real estate professionals to do that, there's widespread non-compliance. low levels of suspicious reporting. Law enforcement say very low quality of suspicious reporting. And the trade bodies will say low levels of awareness about that responsibility to report. So really the prevention side, the whole system that's meant to prevent this kind of money laundering isn't taking place. The same methodology can be applied in lots of global cities. So for all of you coming from global cities, go back and see what you can find with regard to how much property is held by offshore companies, secrecy jurisdiction incorporated companies. Transparency International adopted our London methodology and applied it in Sao Paulo. And yet again, we see large numbers of real estate in the highest luxury end of the market being held by companies incorporated in secrecy jurisdictions. British Virgin Islands, Delaware, Uruguay were dominant in Sao Paulo. So what to watch out for in this evolving issue? A bit of doom and gloom in terms of my presentation. Well, not quite. So there is wider recognition of the problem, which is good. You know, the first step in a policy response is recognition of the problem. UK, Canada, US all recognize in their national risk assessments for money laundering that high-end money laundering through the real estate sector is an ongoing risk. Beneficial ownership transparency is growing. So a lot of countries are committing to some level of transparency over corporate ownership, particularly driven from the EU 4th AML directive. South Africa obviously progressing as well. And there are new tools to enhance enforcement. So there's a lot of interest here in the US about the application of the FinCEN, what's called the Geographic targeting orders. So applies in a few jurisdictions here in New York, in Miami. It was piloted in 6 metropolitan areas in the US, and that requires the insurance company around the land title to disclose the ultimate or the beneficial owner on request of FinCEN. What they've found is that for the highest end of the market, where they've asked for that disclosure of beneficial ownership, 30% of the responses that come back link back to individuals or entities which they've already identified as suspicious. So it reconfirms that feeling that in the US there's a very high level of risk when it comes to the luxury end of the market and ownership through offshore corporate entities. In the UK and in a number of countries, there's a greater emphasis on regulated entities and law enforcement having a level of dialogue around financial crime risks. That's improving the capacity of that prevent side. And we're also seeing the growth of what's called unexplained wealth orders, UK, Australia, and Ireland, which provide law enforcement with a much quicker way to respond to suspicious reporting about money laundering and ultimately to support asset recovery. It's also worth watching at the political level public discontent. So we're talking about property. I'm not sure in all the world if it's as emotive as it is in the UK. But get someone talking about house prices in the UK and they will go on for hours, probably up there with weather, you know, if you want to start a conversation. And the opposition to what's called buy to leave. So a lot of these investments in property at the high end of the real estate market, you know, aren't actually occupied. So the indicators that suggest whether activity or people are using the house in the luxury ends of the market are very, very low, like electricity use, water use. And side by side with that, there's a housing crisis in terms of availability of housing in the UK. So it's a political issue. At a city level, there's lots that can be done. You know, if you have some responsibility for data publication, data quality, to help improve this vulnerability. So I think you'll have access to all of these slides. So you know, don't worry about writing all this down. And ultimately, we're talking about ending the veil of corporate secrecy over property holdings. I mentioned the kleptocracy tour at the start. It's run by the guy on the left. Roman Borisovich, who's an anti-corruption campaigner originally from Russia, and this is me with him on the day that the UK announced that all company holdings of property in the UK would be compelled to disclose their ultimate beneficial owner as a legal requirement, and there'd be a criminal penalty and ultimately an asset recovery penalty down the line if there was a failure to comply. So that was a policy commitment. Since then, we've had a bit of turbulence, you might have noticed, in UK politics. So this commitment was made in May 2016. We then had Brexit. We've had 2 changes of government since then. So we're yet to see the actual policy executed. But as we heard from our keynote at the start of this conference yesterday, with anti-corruption, it's all about follow-up. So Transparency International, other actors involved, Roman Borisovich will all be involved in follow-up for that commitment. If it goes through, it'll be interesting to see how other global cities follow suit. I'll stop there.
Great, thank you. So I think we've got about 5-10 minutes left for some questions, and I thought in the interest of time I'd open it out to the floor first to see if anyone's got any questions for our panellists. Yes, yeah.
I had a question for Mr. Maxwell. I wonder if you are familiar at all with the United States EB-5 visa program. I work for a legislature of a local government out on Long Island that recently renovated its sports arena, and it was only after legislative approval of the transaction that it was brought to light that some of the financing was being done through the EB-5 investment process, and there were real concerns with whether any of that money was the result of corrupt activities from the immigrant investors. And I don't know if you can shed any light on the problems with that program or issues.
Yeah, absolutely. So another research project that I led was around the UK system for golden visas. So right across the world, there are big money laundering concerns when it comes to golden visas. In the UK, there was a period which we call the blind faith period, whereby the government said, we're concerned about the potential risk when it comes to money laundering. So to achieve a golden visa, the applicant must get a UK bank account, and therefore there's an assumption that the UK banks would do their anti-money laundering checks. But over a long period, the UK banks used the fact that the government had provided a conditional support for their golden visa as, well, if the UK government has supported this, we're happy enough, in terms of our AML checks. And there was a circularity which resulted in, a blind faith period for money laundering. A very, very large amount of funding came into the UK through that period. The vast majority of recipients of golden visas in the UK, this is where you can get a residency and ultimately a visa in response to the promise to invest money in the UK. It started off as £1 million, then went up to £2 million. And the vast majority of beneficiaries of that program in the UK were from China and Russia. So there's particular interest in China about following up some of that in terms of their anti-corruption drive, less so in Russia. But certainly across the world, those systems are a cause for concern.
Just a follow-up question based on this gentleman's question about EB-5. Have you done a cross-analysis of the immigrant investor programs and the patterns of illicit flows that you're seeing here, or because I would imagine there is an analysis to be done there too? Yes,
so the answer is no in terms of international comparison, but Transparency International were looking at that. The challenge is that in the reports that are available, very limited information can be disclosed about what the investment was tasked for. In the UK government, they just didn't they didn't record that information, so it was all available as paper, and they weren't in the mind to report it when we were asking them to. So yeah, I think it's a good area for further research.
I have a couple of questions too, Jen.
I have a question for Wilson, and I don't know if you'll be able to answer this, but I'm going to throw it out there anyway. So having been an AUSA in both New York and San Francisco, they have very different oversight structures. There's no IG in San Francisco or even anywhere in California, really, as compared to New York, which has DOI and the state IG and more bodies who are looking to do investigations, which if they are turning criminal, they'll bring to a prosecutor's office. So obviously your office, your old office, was able to do the Leland Yee case and does other public corruption work out of the U.S. Attorney's Office. But do you think that not having a kind of Inspector General's office like the ones we've been talking about at this conference means that there's less of that sort of work being done? You know, what do you think about the amount of casework being done in California, and whether it could be and should be enhanced by the kind of oversight that we're hearing is being done by IGs?
I think that's an absolutely correct point. In my view, there's a lack of enforcement culture in California and the West Coast in particular. I think to a certain extent, that's because I think the West Coast has a sort of inherent cultural distrust of the government, and also a sort of disdain for law enforcement. That's not present in the rest of the country, certainly not in New York. And also, but you're absolutely correct, San Francisco itself doesn't have an IG. It's a city of only 800,000 people, so there are fewer resources than in New York. But there's also no political will to hold any, to fully look at any of the city programs. Any efforts to, say, for instance, examine city discretionary funding has been rebuffed by the politicians, each of whom are beholden to particular interest groups. And so I absolutely agree that I think there is under prosecution in San Francisco, and I think in all of California. To a certain extent, I think the political establishment on the West Coast and in San Francisco favors the status quo because of the fact that it is not transparent. And I think that there are problems that go unlooked at. The U.S. Attorney's Office in San Francisco is relatively small, especially compared to New York. And it only does maybe one notable public corruption case every few years, and that's really shocking, given that it is one-party rule, given also that I think you hear more intel, you hear more facts in the background about corruption that's going on, but no action is ever really taken. And I think if more resources are devoted and more institutions are created that go after corruption, there will be an uptick in prosecutions and other related actions.
I think you should run for office, Wilson.
I need to raise money.
So just a couple of questions from Mary. Mary, does your office work exclusively with the two deputized state attorney generals, or do you do cases beyond either their unit within that office, or do you do cases with the U.S. Attorney's Office, or do you work just exclusively with the two deputized prosecutors who are part of your office?
No, that's a great question. No, we go way beyond that, actually, because those two people, as you can imagine, end up backed up in their caseloads. So we work with the rest of the prosecutors in the public corruption unit of the state attorney's office. You know, depending on the type of crime, like living wage, we'll go and work with prosecutors in the economic crimes unit of the state attorney's office. We also have ties in the OIG to the U.S. Attorney's Office because my deputy ran the FBI corruption task force for a long period of time when he was with Miami-Dade PD. So we've got those kinds of relationships too. So we more often take our cases to the state attorney's office, but we certainly have relationships and occasionally take it federal.
It's a great resource to have. I have another question. You had said that your perpetrator lost his pension. Did he lose his pension entirely, or did he lose his pension in order to pay off fines, restitution, et cetera?
No, he lost his pension.
So
And we
that's
actually have
permissible.
a mechanism whereby if we're doing an investigation, we put a hold on the subject's pension. So we just basically, it's a phone call to the HR piece of the county, and then they'll actually put a hold on the pension so that depending on where the investigation goes, somebody can't resign, grab their pension and go when they shouldn't get that pension, because you don't get it if you're
And so quite obviously, the law in Florida permits that, permits
Yes,
the
yes.
cessation of a pension. It's amazing as well. And then we were with Chris Mazzella a couple of years ago, Amy Curlin and I, at a conference, and I'm not sure if I'm remembering this correctly from him, but I thought that he had said that your office receives a percentage, not even one full percentage point, but a fraction of 1% of each contract that the county enters into for purposes of oversight resources. Am I remembering that correctly?
And it's not, I was talking to, I think, Amy about this. It's a quarter of 1% of most contracts. There's a few categories in the law that are exempted, but by and large, for most contracts that are let by the county, entered into by the county, the vendor really pays 0.25% of that contract to fund the office. And it's not, okay, we enter into a contract, I'll just use Econolite because I used the example earlier for whatever, $50 million. Okay, you don't get 0.25% of that $50 million. It's as the billing occurs. So,
Is that on top of your $7 million budget?
no, that's
That's
a
part-
big
that's
piece
what's
of what
funding it?
That's the vast majority of what funds it.
Got it. Thank you.
Okay, great. I think we've run out of time.
I'm sorry, may I ask one more question? Okay, thank you. I appreciate it. This is for Ms. Cagle. As I said, I work for a legislature on Long Island, and we have our fair share of public corruption issues. Our county executive and his spouse are under indictment, federal corruption charges. His counsel is under indictment, federal indictment. His chief deputy is under federal investigation. The county, the supervisor of one of the major towns was also indicted in a procurement scandal with the county executive. So there are some real issues out there that I'm trying to address on behalf of the legislators whom I represent. We have proposed a fairly comprehensive Inspector General bill modeled on Miami-Dade and Palm Beach, which we've been trying without success to get some traction on. One of the, two of the objections we hear about the bill is that, one, because of the independence of the proposed Inspector General, he or she won't be accountable to anyone and could be a rogue that no one will be able to control. And two, the office is redundant because we have a district attorney who's supposed to conduct these public integrity enforcement measures. And I wonder if you could comment on those two objections.
Yeah, I mean, I don't think it's redundant to criminal prosecution. We've had this dialogue for the last 2 days, right? Because you don't just do criminal prosecutions, you're also looking administratively into county departments doing inspections, reviews. And so, out of that comes real value to the city or the county government, right? Because you basically sit down and go into that department and do an audit or a review that sheds light on issues that need to be addressed. And so I tried to address this at the beginning of my comments. The relationship between the IG has to be really a positive, or it's helpful if it's a very positive relationship with the administration, because in that dialogue, again, because we're not just going gotcha at the end of it, we're having dialogue with them as we do the inspection or the audit. At the end of that, if you have credibility and they think you're competent, they kind of, you've taken your time, not their time, to do all of this, and you can hand them a set of recommendations that they then think are really valuable to address some issues in their administration, and they implement them. So I think it can be a real boon for the administration to have an IG in their guts, depending on what the relationships are like. You don't want to go too far and be their best friend, but what was the first thing you asked? I'm sorry.
The first thing was the danger of the IG not being sufficiently accountable.
Right. And so IGs go through peer reviews every 3 years for the audit side of their house, and I know we go through an accreditation process for the investigation side of the house every 3 years, the same process that law enforcement goes through. So I do think you need to set up your office so that you do have outsiders coming in and looking at you on a regular basis, and when they do, it's not a soft, nebulous sort of look at your office. I mean, they pull every file, go through everything, and, make sure that you're working to the standards you should be working to. So I think it's really important.
Thank you.
Okay, please join me in thanking our panelists today.